You're close enough. We may as well begin. Last time we began the discussion of the object and effects distinction in Article 101. And actually we didn't begin, but we're about to begin that discussion. But as a sort of a preface, an introduction to that, we went over the doctrine of ancillary restraints, or the view of ancillary restraints. Now, an ancillary restraint is obviously an agreement which is anti-competitive in its face, but it's in effect a secondary agreement. That is to say, an agreement that is incidental or ancillary to the main agreement in question. So, for instance, in a sale of a business, okay, the main agreement is, of course, the transfer of either the shares or of the assets of the business. But as part of that contract or that arrangement or the agreement, the parties would want to non-compete, okay? Because in the absence of a non-compete, it is unlikely that the main contract would be acceptable to all parties. Likewise, in a transfer, there may be a transfer of the business's intellectual property along with the sale of the business, so various licenses to use certain intellectual property may be there. Now, if an agreement is truly ancillary to the main agreement, then that ancillary agreement is unlikely to, in fact, almost certainly will not breach 1011 unless the main agreement breaches 1011. So, it's the sort of things that are strictly necessary to ensure that the main agreement comes into place. Now, when we get to vertical agreements, we'll see that there are a number of various types of vertical agreements, one of which is a franchise. Now, franchises are very common and a very good way of sort of vertically integrating a firm. Okay, we see all, I hate to use the word tons of them, but we see a lot of franchise agreements, right? McDonald's, Subway's, the food industry. You see often franchises in sort of the automotive industry. A garage or a shop might be franchised to sell tires or to perform certain repairs under the brand of the franchisor, okay? And in franchise agreements, you'll see a lot of so-called ancillary restraints, which we'll get to in greater depth. So these secondary or ancillary restraints are very common out there in the world, and when you are in practice and are dealing with these sort of business-to-business type arrangements, not just beware of them, but beware that they're out there, and beware of their existence and their purpose and their legality. Okay, and probably the most recent case is the MasterCard, where it further reaffirms the legality of ancillary restraints, so long as that they're necessary and proportionate to the objectives of the main agreement. So, what would disproportionate be? Take, for instance, a non-compete clause. Okay, if the non-compete clause says that you can never compete anywhere else in the world forever, that's probably disproportionate, right? For instance, if it were the sale of a restaurant, it would have to be limited in scope and geographic region. And proportionality is often measured by the terms of national law on point. You get that in contractual restraints. Okay, so that would be up to a national judge to look at. And again, other paragraphs in MasterCard. Okay, and the key is it necessary to inquire whether the main contract would in effect go through or be acceptable in the absence of the ancillary restraint. Okay, now, that's the doctrine of ancillary restraints. The object-effect distinction. This is, I wouldn't say the most difficult, but this is a fundamental point of understanding Article 101, Paragraph 1, 101.1. Okay? Agreements between undertakings which has as their object or effect the prevention or restriction or distortion of competition are prohibited. Okay. What does this mean and what are the implications? The implications, we'll start with the implications, are quite profound. We have an arrangement. You need to determine whether the arrangement restricts competition by its object or by its effect. We'll get to that in a few minutes. Okay? If it restricts competition by object, the only way of justifying it or legalizing it is through the provisions of Article 101.3, which we'll get to either later today or tomorrow. Okay? That's the only way it can be justified. Now, you might say, fine, great, fine and dandy. The problem is, even though, and there's case law on point, in theory, any agreement that violates 101.1 can be saved by 101.3. In theory, it's a very hard mountain to climb. Okay, it's a very difficult task to justify an agreement that violates 101.1 under 101.3. I'll tell you how hard it is. It's almost impossible. Okay? There has been precise, to my knowledge, and actually, in my research, looking at everybody else's, what they say about their knowledge, there's been precisely one case, okay, since 2004, in which one national competition authority, not the commission, but a national competition authority applying the national version of the competition rules, which are based upon the European Union rules. There's been one case in which an arrangement that violated 101.1 was justified under 101.3. And that involved a web taxi case in Luxembourg, where the Luxembourgish taxis, about 23% of them were using a web-based device similar to Uber that was fixing prices. Okay, one case since 2004. Okay, and the, how should we say, the academic discussion surrounding that case is mixed. Some people think that's great. A lot of people think that the Luxembourgish Competition Authority made a profound error. So one controversial case. The decision, by the way, if you want to read it, it's on the Luxembourgish Competition Authority's website. Unfortunately, for the bulk of you, I'm sure it's in French. Okay. It's not. There's no English translation of it. Okay, so you just have to take my word for what it says. I've read it. Okay. Advantage of growing up in Canada, you learn French, whether you like to or not. Okay. Okay. Now, you notice I said since 2004. Okay. We'll get to this in greater detail. The Commission's and the member state authorities' thinking about 101.3 changed as a result of Regulation 1/2003, which took effect in 2004. Okay, we'll get to that when we talk about 101.3 in more detail. Okay, so, otherwise put, if you have an arrangement that's an agreement, concerted practice, or whatever, that is a by object restriction of competition, it can only be justified under 101.3, which is difficult. On the other hand, if you have an arrangement that has as its effect, okay, a restriction or distortion of competition, then you need to do a full-fledged analysis, a full-blown economic analysis of the pro and anti-competitive consequences of that arrangement and determine whether on the whole it promotes or restricts competition. Okay, now this distinction is, how should we say, puzzling. Polite word of saying difficult, okay? The clearest discussion that I can find, that I found, is the Advocate General Bobek's opinion. There is another recent discussion, and that is the judgment of the ECJ in UK generics. That came out on the 30th of January. Okay, the opinion came out a few days before the judgment. The judgment is finally out. I've put it on the blackboard, and if the photocopy gods shine on me today, I will make copies of it and distribute it in class tomorrow. If the photocopy gods are their usual devilish self, I'll have to leave those the copies with the TSSO tomorrow. Okay? So, but this is worth reading. I spent Saturday writing a case comment on this. The more I read it, the more useful I think it is. Okay? But the AG's opinion is quite good on point. Okay? Now look, the other case that's worth looking at in some detail are the paragraphs from the CB case, Carte Bancaire, which is the bank cards decision. And the relevant paragraphs and sections are on the slides, as well as listed in the syllabus. Okay. Well, an object restriction recognizes that there are certain forms of agreements or conduct that are just so harmful to competition, they're incredibly harmful to competition, and have no redeeming values. Okay? A sufficient degree of competition, of detriment, of harm, that there's no need to examine their effects. What would these include, do you think? What would these include? Just so detrimental to competition.
Fixing prices,
Yeah, exactly. Fixing prices for no other reason than fixing prices. Okay, horizontal price fixing. You know, two alleged competitors fixing prices. Okay, what else do you think might be there?
Market sharing.
Market sharing, exactly.
Bid rigging.
Bid rigging, yes. All of those, and anything else?
collective boycott.
Collective boycotts can be, yeah, without a particular reason.
A group of competitors agree to exclude one competitor to join their agreement.
Yeah, unless there's a reason.
Um,
That would probably, yeah. Anything else? Output restrictions. Agreeing to cut back on production. Okay, all of those, okay, particularly in the absence of any good reason. Okay? You know, a group of companies may decide not to sell to someone else because the person to whom they would sell to doesn't pay their bills. That's a good reason. But in the absence of something like that, those kind of that kind of behavior serves no competitive purpose. Companies that are on the same level of the distribution agreement, of the distribution chain, agreeing to fixed prices. Again, there's no pro-competitive reason. So we know that certain types of coordination between undertakings reveal a sufficient degree of harm to competition. So we know that. Okay? So when we see this behavior, okay, we say this is a restriction by object. Okay? But to say I know it when I see it is very vague as a legal criterion, correct? Okay. Very vague. I know it when I see it. So what precisely is it, and how do we, how do we see it? Okay, again, we'll look at, so we talk about price fixing by cartels, arrangement of the price, quality, quantity of goods. It's, this is all redundant. We draw on our experience. Experience shows us. Okay, this is how we know it. We know it because we have some form of experience, but it's not just general experience, as we'll see. Experience tells us that, for instance, this cartel price fixing leads to falls in production, price increases, and in particular, consumers are worse off. Okay. But again, okay, so this clarifies its experience somehow, okay? It's still a bit vague. Let's look at the AG's opinion. Okay? And the AG's opinion, that even though it's not law, okay, even though it's not law, it restates what the Advocate General believes the law is. It does so quite clearly. And typically, Advocate General's opinions are followed by the court. I think the Advocate General's opinion is also very consistent with what the court said at the end of January. Okay, so I think this is a very good statement of the law. Okay? Now, agreements in European competition law must be looked at in their commercial context. Okay? So some understanding of the commercial realities facing the undertakings involved needs to be had by those evaluating the agreement to put the agreement into its commercial context. Okay? So you need to look at, first of all, the content of the agreement. Okay? Looking at its provisions and objectives. what are these two undertakings, or more than two undertakings? What are these various undertakings attempting to do? What are the market conditions that the undertakings are facing? Okay. Then you need to examine precisely how that agreement is anti-competitive. So to verify the anti-competitive nature of the agreement. Page.
One question.
Yes.
Even in the end, he says like when you after you examine these in light of their experience, you just still look through their experience what is generally
Right.
used. So
Yeah,
it still pulls up the concept of in your experience.
It's usually we'll get to this in a minute. But economists and competition policymakers have a lot of experience with hardcore cartels, right? We know, and this experience is also informed by economic theory. So it's really informed experience. So even simple economic theory of the sort that I illustrated in the second 3 weeks ago shows us what's so harmful about price fixing cartels. Okay, so it's this sort of it's not just sort of random experience that we get while out for a stroll, but it's the sort of experience that competition policymakers, competition lawyers, competition economists have, informed by, in this case, either the commercial context of the agreement and principles of microeconomic theory. Okay, so you'll see that in, and that will be in, what paragraph is it? 42, point 42, he says. What, in that regard, experience must be understood to refer to as what can traditionally seem to follow from economic analysis as confirmed by the competition authorities and if necessary supported by case law. Okay? So it's not just, the sort of experience, it's not untutored experience. Okay. Provisions and objectives. Then you need to verify the anti-competitive nature of the agreement. Okay. And this analysis must be done in context. Okay, and this is the key. In context. Okay. You need to know what are the provisions of the contract, of the agreement, what are the objectives it seeks to attain, and what is the legal and economic context. Okay. And then this is the GSK case. Now, a lot of the object and effect distinction draws on, how should we say, unusual markets. Okay. Most of our experience and most economic analysis that underlies this sort of informed experience that we were talking about deals or has been obtained through looking at normal markets. I go to the grocery store and buy a head of lettuce, right? Typically, in those markets, you have producers and consumers, okay? And then everything works out really nicely, okay? The problem is that you get markets that don't exactly work that way, in the clearest fashion, okay? So when the market is different, the analysis must be different. Okay? The CB case that underlies a lot of the discussion of objects and effects, and Budapest Bank all involve bank card fees. You know your bank card. Okay? How does that work when you go to a merchant? Okay? It's not a one-sided market, right? it's a two-sided market. When you go to a store, okay, or a store will only take bank cards if a sufficient number of its customers will use them, right? Right? And customers will use bank cards only if there are a sufficient number of stores that will take them, right? No point in having a card that you can't use. You know, leave it at home on your dresser, in fact. Okay? So in these markets, it's a two-sided market. Okay? You have to look at the consumer's preference and a lot of merchants taking them. Okay? And you have to look at a lot of merchants, their preferences, or they require a lot of consumers to take them. Okay, so this is what's known as a two-sided market. An analysis on two-sided markets is slightly different, or very different, from analysis on one-sided market. So a practice could have effects on one side of the market, or benefits on one side of the market, and an effect on the other side of the market, and vice versa. So the pro and anti-competitive effects on each side of the market need to be weighed up. Okay? Now, in CB and in the MasterCard case that's also referred to, and in Budapest Bank, the problem surrounds interchange fees. And these are fees that are applied in every card transaction that you in Europe won't see. Okay? There are two types of interchange fees. One is a bilateral interchange fee agreed between banks in the transaction, and a multilateral interchange fee, which is a default fee. Now, obviously, with a card, you want to be able to use it irrespective of what bank the merchant banks with, right? Okay. So the whole idea of the multilateral interchange fees is important. Okay, it's a default fee. I mean, there's nothing worse than going into a store or using a bank machine and finding out that you can't because of a different branch. It doesn't happen in the UK or Europe because it's well linked, but I recall being in Indonesia some years back, and I put a Visa card into a MasterCard machine or vice versa, and I couldn't get any cash out, and the explanation came across in Bahasa Indonesia, and I had no clue what was going on. Finally somebody explained it, MasterCard Visa machine. So I had to go find a different machine, thinking, oh God, criminals have taken all my money out or something. I was stuck in Jakarta with no money. Anyway, but so that's important. These fees for the working of the system. Okay, now how do these things work? Here's a nice diagram of a card scheme. Okay, listing the interchange fee. Consumer goes to the retailer. Okay. Consumer receives the goods. Okay. Uses their card. Okay. The issuing bank takes the money out of my bank. Okay. Sends the money to the acquiring bank, which then sends the money to the retailer. Okay, every time I use my card. Okay, and I get my toaster, I guess it is. Now, with each of these, there is a fee associated with. Tends to be no fee here. Some places, at least in Canada, there is a fee. Okay. What will happen is the issuing bank will have to pay a fee, a small fee to Visa or MasterCard. Okay. Same with the acquiring bank. Visa or MasterCard gets its share. Okay. The acquiring bank, so the merchant's bank, will pay the issuing bank, the customer's bank, a small fee. and then the merchant will pay a small charge to the acquiring bank. Okay, so it's these fees here. Now, in here, this is the bilateral exchange fee, if there's an agreement between these two banks, or the multilateral interchange fee, if there's no such agreement. This is a contractual agreement between the retailer and the issuing bank. Okay, it's usually imposed by the acquiring bank, usually imposed depending upon the business and the risk. Okay, so that's how things work. So these cases all involve the level of these fees. Okay, now, in particular, the case involved fixing a floor to the multilateral interchange fee. Okay, so in effect, the card scheme, the CBE and MasterCard, fixed this when the banks didn't have an agreement between themselves. The problem with fixing a floor like that is it looks like price fixing, right? Very much. It looks like, in this case, CB or MasterCard has fixed the price of these interchange fees. Okay? And in a regular market, you know, the customer buying the head of lettuce type market, you would have to agree. But the problem is this isn't a regular market. The only regular market aspect to it is here. Right? Okay. So examining the commercial context is key. Now just as a sort of a footnote or jumping ahead of it, in CB and MasterCard, the Commission treated this scheme, okay, like a regular market and failed to look at the two-sided aspect of it. The Court of Justice said, this is a problem, you didn't look at it in the appropriate commercial context, go back and reconsider. Okay? Because of the complex nature. Okay? So, the first step in this is to see where the harmful nature is in the light of experience commonly accepted and easily identifiable, blah, 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 blah. Now the problem is, or the point is, in a normal market, we have lots of experience. We have lots of economic analysis. Okay. And they would say that in a normal one-sided market, this behavior is price fixing. In the interchange fee case, we don't have a great deal, a significant amount of experience. Or at least what the Commission showed is that they didn't apply a significant amount of experience in looking at the market context in question. Okay? So that was the error in those cases. Okay? And then you look at, if you have the experience, is this the sort of practice that are commonly understood? So in those commonly understood practices in normal markets would be 101.1, and then there's a bunch of lists in our various textbooks. Okay? Identify those. Then the second step is for the authority, that is to say the National Competition Authority, verifies this presumed anti-competitive activity, okay? Not on a merely formal assessment, not by looking at it and saying, oh, that looks like price fixing, therefore that is price fixing, okay? But in a deeper analysis, looking at the legal and economic context, sure, it looked like price fixing in a one-sided market, but it's a two-sided market, so it's not really price fixing. Okay. And then you need to take into effect the nature of the goods and services affected, the real conditions of the functioning of the market. What would happen, for instance, if MasterCard didn't set a default multilateral interchange fee? What would happen? Okay, and the reason MasterCard established a multilateral interchange fee is because in the absence of negotiation, this is going to be it. So what would it mean? It would mean a number of banks you couldn't use the cards in this system or between certain banks, right? And what would that do? That would reduce the number of potential customers and the number of potential merchants that could use the system, and therefore reduce the usefulness of the system. Okay, you see that? Okay. So you need to take into account the restriction in the context of it. And this includes a basic reality check. Is there something about either the nature of the agreement or the nature of the market? Okay, which has doubts on whether or not the agreement or the practice in question is harmful. Okay. In CD in Budapest Bank, it was the multilateral interchange fee. Okay. Is there some specific circumstances about the market? Yes, two-sided market, involving lots of banks, lots of customers. Do we have a lot of experience with that? No, not really. Okay? So, because there are specific circumstances, that should set off a red light. And it does set off a red light, according to the Advocate General. Okay? And then said it's sufficient for the authority, do not have any. So if there's no special features, that's it. If there are special features, okay, looking at the real world context, looking at the actual operation of the agreement in the commercial context, then competition authorities have to take into place. It's a basic reality check. The special circumstances, basic reality check, rather general level, okay, that preclude the agreement. There's no standard type of analysis of depth or meticulousness, okay, so it's on a case-by-case basis. Is there something about this particular case that sets it out from the norm in its economic and commercial context? Okay. And then he says, again, this is a problem though. It's impossible to second step and an effects analysis. We'll get into that in a minute. Okay, has significance. So, the test, according to the Advocate General, okay, does the agreement fall within a category of agreements that experience, and when I say experience, I say etc., experience informed by economic theory, competition policy show to be harmful for competition, And then second step, is there anything particular to this agreement that might indicate a pro-competitive aspect of the agreement? Of it. Okay. If the answer is yes, and the to 1 is yes, and the answer to 2 is no, then it's a restriction by object. If it's yes, yes, then it's a restriction by effect. If it's no, irrelevant, then it's possibly a restriction by effect. Okay. So that's restriction by object. Restriction by effect. Okay. A full-fledged effects analysis must be carried out for the purpose of Article 101.1 is to determine the impact, okay, that has on the relevant markets. And this is how it is done. Okay? The authority has to compare the competitive structure on the market with the competitive structure which would have prevailed in its absence. Okay. In competition babble, competition speak, you look at the market and the competitive structure with the arrangement in place. Okay. You then construct what's known as a counterfactual. Okay, a what if. Okay. You look at the market and try to determine what competition in that market would look like if the arrangement, the agreement, wasn't in place. Okay, you see that? So there's the hypothetical. What if the agreement wasn't in place? Okay, so you'll see that as it'll be the counterfactual. Okay, and then you compare the actual conditions of competition in the market with the agreement in place and the conditions in a hypothetical market where there is no such agreement. And you look at the state of competition there, prices, market entry, etc. Okay? And that allows you to determine the pro and anti-competitive effects of the agreement, and then you assess whether the agreement is harmful to competition. Okay? How is this done? This is typically done by good old expert economists. Okay? You will get, if you look at the syllabus, I've given you a number of a couple of references to it. Oxera is one. There's these consulting economists by the dozen, okay? And they're hired to produce these sorts of analyses. And in addition to them, competition authorities, in particular the European Commission, the competition division, has their own set of expert economists. Okay? So what you need to do is to look at the net effects of the agreement, whether they're positive and negative, based upon the data provided to you by the economists. This is really a question of fact. A question of fact introduced or produced by relevant experts. It's not really a question of law. So you, as a practicing lawyer, don't have to worry about wading through the data. Okay? Well, you probably should read through the data before you submit the expert's report, but it's not your job to come up with the data. Okay? You pay somebody, or rather your client pays somebody to do that. Okay? So for an exam situation, you're never going to see something like that. Okay? More relevant, I guess. Okay, now, as I said, the consequence of restriction by object is a defense under 101(3). Okay? This is available to any agreement, and here's the case law that says so. Okay? But as I said, this is highly theoretical. One case since 2004 in the Luxembourgish taxi market. Okay, now, where are we at? Okay, 5 more minutes, good. Judicial economies. The nice thing, okay, about a restriction being found as a by object restraint or restriction is that it shortens the litigation process. Okay, so there's a judicial economy there. You show that it's an object restraint, or sometimes in competition babble. This is Richard. I think it's found. I don't know if Wish came up with it, but if it fits into the object box. If it's an object restraint, then the onus switches to the undertaking or undertakings involved to justify under 101(3). Right? This is where does this proposition? What's this based on? This is Regulation 1, 2003, Article 3, when we're talking about the burden of proof, right? It's on the competition authority to show a violation, and then it's on the undertakings involved to show a defense, right? So the authority shows it fits in the object box, it's an object of restraint, and then the onus then switches to the undertaking involved to show either it doesn't fit as an object restraint or alternatively there's a 101(3) defense. Now note, step 1 does not involve the production of a huge amount of economic evidence. I've got a price fixing cartel in front of me. You agreed with them to fix prices on widgets. End of game, right? Okay. And economic evidence acquiring that can be expensive. There is, what was it, 2010 or 11, there was an American Supreme Court case that pointed out in the U.S. a market analysis, just in the product market alone, can often cost $1 million US. Okay, so economists, these competition economists that are used in litigation, charge a lot like what lawyers do. And their offices look like lawyers' offices with brass, glass, and ferns. Okay? So, by object restraints, there's a fair amount of judicial economies there. But, by effects, restraints, okay, much more expensive to litigate. Requires a detailed market-focused analysis described by the AG. Okay, in other words, you need that whole counterfactual. Here are the competitive conditions of this market. What would the market look like without the agreement in question? So on and so forth. And furthermore, 101(3) defenses apply to all agreements, including those that are restricted by effect. So you get the first set of analysis to determine whether it's by effect and what the competitive conditions are. You would argue, first of all, that it's pro-competitive, but alternatively, if it's anti-competitive, it can be justified by 101(3). So that sort of litigation is longer, more protracted, more expensive. It involves a lot more technical evidence. Okay. Now, The economies work if there's a clear line between object and effect analysis. You know what you're doing at the beginning, and you form your litigation strategy accordingly. Okay? But if the line is blurred, as the Advocate General's suggestion hints it might be, this jeopardizes the economies, particularly at the margin. You're not knowing whether a certain practice is by object or by effect. Okay? And in Alliance Hungaria, okay, following those agreements in particular, look at everything, okay? The line got really blurred in Alliance Hungaria by almost suggesting that there is no line, and even in the by object case, you need a full-blown economic analysis. Okay, that's a bit of a disaster, and it appears that the court is trying to paint a bright line between the two. It backpedaled from Alliance Hungaria into the CV case. Now, what are object restraints? As I said, look at Article 1011, look at Commission guidelines on block exemptions, on hardcore restrictions. Also in your textbook, on an earlier slide, I gave you the pages. There are some lists of what are generally thought to be by object restraints. I'll take a 10-minute break now, talk briefly about small market shares, and then we'll look at 101.3. Okay? It's a mess today. Yeah, I've got a syllabus, but I don't. Okay, this. That's the case on the side. There's a syllabus.
Yeah, you can.
And I've got stuff on my office after class, but before 1 o'clock. I'll give you a hard copy. You want to do some 3, 6,
Question about industry strike will be strike and
About, whether I'm going on strike?
yeah.
No, I don't strike.
Okay.
Oh,
How about the seminar?
I don't know, but I'll
Because I
sort.
checked during this period, there will be 3 weeks involving about the lecture and seminar.
Yeah, I think there's only one seminar.
Yeah, just one seminar.
Okay, I'll deal with that.
Okay,
with
thank you.
everybody.
Dissertation title.
Pardon?
Dissertation title.
Yes.
And when you upload it.
I haven't uploaded anything. No, you have to come up with your own. Okay. Okay. Okay, may as well begin. I guess a couple of administrative points to begin with. First is the feared industrial action, aka strike. I will not be striking, so lectures will go ahead. Okay, on schedule. Only way that lectures don't go ahead is if I'm sick, dead, or somewhere in between. Okay? or there's some major transportation problem, but I just take a bus into work, so it's not like I'm commuting in from the middle of the Peak District where some trees falling on the train line. Okay, so, however, I'm not sure about the tutorial. My Ms. Toll, who will be normally taking the tutorials, hasn't informed me, which is her right, whether she will be on industrial action or not. If she isn't, that's fine, that's great. If she is on industrial action, I should know. And what I intend to do is I will cover, we may have to move both groups into one group and just do a rather large tutorial. Okay, but that teaching time will be covered one way or the other. Okay, even if it is as a huge tutorial versus two smaller tutorials. Okay. Second, dissertation topics. I haven't set any list of them. If you want to do something in competition law, that's your prerogative. What I would suggest you do, okay, is to find something that interests you. There's no point in writing on something that you hate, because you'll hate it even more once you're finished writing it, okay? You always start out with a project that you love, and by the end of the thing, when it's finally done, you hate it, okay? And I know this all too well. I finished a book in the autumn, and by the time the proofreading and the like was done over the course of the autumn, that was on last Wednesday, I finally sent off the last of the proofs, and I just, I wanted just to burn the thing. Okay, so start with something you like, and then you'll hate it. If you get something that's assigned to you, you'll really hate it, and you'll hate me for assigning it to you, okay? Now, how do you get something that you like? Okay, you go to the textbook and look through it, okay? See, read it. Does this look interesting?
It's because, the book 8,000.
Yeah, I know, it's 8,000 pages. But that means there's a lot of stuff in there, so there's got to be something you like.
Yeah.
Okay? Yeah, I know. The book's it's fairly like, look through, find something that interests you, and then maybe not just one thing, maybe a couple of things, and then if you want, come and see me. Okay? And we can certainly narrow things down. Okay? Does that make sense? So I can give you 6 topics that I really like, but you'll hate. Okay? Trust me, you will. Okay? Any other questions of that sort of administrative type nature? No? Nothing. Good. Okay. Small market shares. This is the last bit of jurisdictional element. Okay. Couple of things. Okay. If you look at Article 101, okay, and those of you that haven't, people downloaded this and its companion volume. They're listed on page 13 of the syllabus. Commission provides them for free. In it, for instance, there's Article 101, and it refers to the following, which may affect trade between member states as a jurisdictional element. Okay? European Union law, European Union competition law deals with trade between member states, trading goods or services between member states. As I said, if it has an effect only on a national market, right, so market definition here, then the Commission doesn't want to hear about it and let the member state authorities deal with it. Okay? Now, small market shares. Okay? Small market shares and practices that occur among undertakings that collectively have a small market share tend not to be harmful or as harmful to competition and tend not and tend not to affect trade between member states. Okay? So, two things, okay? The two ways the European Union rules deal with this. Appreciability and a de minimis. Okay? Now, keep this in mind, just because it's a small market share, okay, that doesn't appreciably affect trade between member states, the EU rules might not deal with it, but member state rules can catch the practice. Okay? So for instance, the 23% market share in Luxembourg in the taxis, small, didn't affect trade between member states, so it wasn't affecting German or Belgian or French taxis. But, so the Commission wasn't worried about it, but the Luxembourgish competition authorities got involved. Okay? So appreciability and the de minimis. Okay? An agreement may not appreciably affect market share if the market, agreements may not appreciably affect trade between member states if there's a small market share. Okay? And the leading case is Volk and Vervaeke and the STM case. Okay. Volk and Vervaeke involved white goods, I think it was refrigerators. Selling about 1,000 refrigerators or something in Germany over the course of a year. Okay, now, in these cases, what typically happens, okay, is you have a form of absolute territorial protection. Okay? And there's a small market share involved. Now, absolute territorial protection is the circumstance where one undertaking is given exclusive rights to deal within a geographic area and deal particular goods, and no one else is allowed to deal with those same goods in that area. Okay. Absolute territorial protection can be very useful when you're breaking into a new market. Okay? So, and when you're breaking into a new market, you will necessarily have a small market share, right? Okay. Example. Suppose I'm in Luxembourg and I want to sell a particular brand of harpsichord, let's say. I really like my Baroque music and I want to make the harpsichord a popular instrument. Okay? So I want to set up a harpsichord store in Luxembourg City. Okay? Now, to do so, I need to make an investment. I need to rent the store. I need to have trained harpsichord salespeople, who can play harpsichords. Obviously, probably I need advertising. Probably need a lorry to take the harpsichords from the harpsichord warehouse to the customer's house. So I need to make an investment. Excuse me. And these investments can be significant, at least to me. Okay? Now, what's my fear after I've made this investment? What's my fear once I've made this investment? Yeah, I've set up a new harpsichord, Bruce's harpsichord. It's in the middle of
And no one's gonna show up.
Well, that's, yeah, but okay, then no one's gonna show up, but also, suppose people show up. Okay, if no one shows up, then I really screwed up and misread that market. Okay, but suppose I didn't misread the market, people show up. My fear is that they're gonna come to my store, okay, look at my harpsichords, have my trained harpsichord salespeople, okay, tell them the advantages of the harpsichords that I have, and they go somewhere else and buy it. Go to Trier, okay, or Cologne, or Brussels, and go to a competing harpsichord store there and buy it there, right? Now, how do I prevent that? I ensure that nobody else can sell to people with addresses in Luxembourg. That the Trier store can't deliver to Luxembourg, that the Brussels store can't deliver to Luxembourg. Right? That way my customers can't be scooped. Now, okay, now, I have, so that in effect gives me the market for a harpsichord, or a particular harpsichord in Luxembourg. There's a competitive pressure put on because there might be other competing brands of harpsichords. I mean, let's explain. We don't have to have harpsichords, but you know what I mean. So competing brands of substitutable goods that'll keep the price of my harpsichords down. For harpsichord, you could switch to washing machines, as the Volken Vervaeke case was. Right? There'd be other brands of washing machines. Okay, Siemens versus Grundig or something like that. Okay? So, because of the competition from other competing brands of the same good, I can't really go wild with my prices, but because of the territorial protection, okay, I'm fairly assured that no other dealer of the same product can come and scoop my customers and undermine my investment. Okay? In circumstances like this, EU competition law is likely to say that this is not an appreciable effect on the market. Okay? And EU competition law, and it falls outside the jurisdiction of EU competition law. It falls within the jurisdiction, in this case, of Luxembourgish competition law, but not EU competition law. So even though there are internal market considerations of territorial protection, the actual circumstances of the agreement, what I'm trying to do is trying to introduce a new product and need some protection so that I'm assured that the investment I make is somehow protected. And it's a small market share, sort of for an introductory period. If my market share increases, then I can't do this. Okay? So, if it's not an appreciable effect, then we don't worry about it for European law. Another point here, object and effects also applies to one of two restrictions. That's well brought out in the generics UK case, and we'll talk about it. And you can obviously litigate it jointly and alternatively as that. Okay, now, the other aspect of very small market shares is the de minimis. If it's a really small market share, period, it's a de minimis restriction that the competition authorities, or at least the European competition authorities, and in most cases the national competition authorities, are not going to worry about. Minor restrictions on competition tend not to have the welfare, or tend not to be as detrimental to consumer welfare. Now, the Commission's approach to the de minimis restrictions changed as a result of the Expedia case. Okay? Which means that if you downloaded this volume, you'll see that there's a de minimis notice here on page 137. You can ignore that, tear it out, make a big X through it. Okay? You'll need to go and download a new de minimis notice from the commission and replace it. Okay, and that's the one from 2014. The reference is in your syllabus. Okay. The de minimis notice, okay, Expedia, you look at the accounting nation goods and services, de minimis is just one factor. It's the legality. But points out that in an object, okay, restraint, okay, and it is by its nature and independently of any contract effect has an appreciable restriction on competition. Okay, so what that means is the de minimis thresholds for the de minimis notice provides a safe harbor. What's a safe harbor? The safe harbor is if you meet certain conditions, if your agreement meets certain conditions, and the agreement is deemed not to violate EU competition law. Okay. The de minimis restrictions, okay, stated that below a certain monetary and market share threshold, an agreement was so minor that it was automatically exempted from EU competition law. Okay. And the old de minimis notice said that applied irrespective of whether it was an object or an effects-based restriction. In Expedia, the Court of Justice said no. The Commission got it wrong. Remember, these notices are promulgated by the Commission. They bind only the Commission, not the Court. In Expedia, the Court said Commission got it wrong, and by object restrictions cannot have the benefit of the de minimis safe harbor. Okay. So agreement which has its object or effect doesn't follow out, and so there's a narrower role for de minimis. Okay, and that is the new de minimis notice. Okay. So an agreement between competitors who share 10% of the market and 15% for non-competitors. Those agreements, so long as they do not include by object restrictions, are automatically exempted from the EU's competition provisions. Okay.
So the de minimis effect is essentially. Can you explain the de minimis effect?
Okay. So if you have two competitors, say one with a 3% share and one with a 4% share of the market, they can enter into any agreements. It used to be the case, any agreements whatsoever, and EU competition law wouldn't touch that. Now they can enter into any agreements whatsoever, so long as those agreements are not by object restrictions. Okay? And EU competition law doesn't touch that.
So as long as they're below these thresholds.
Thresholds, it's
they're
safe harbor.
Safe.
Okay? If it's above those thresholds but still a relatively small share, they can say it doesn't appreciably affect competition, therefore EU law doesn't. So it goes back to appreciability. Okay? See, the de minimis threshold is automatic. You just show that your market shares are below that, and it's not a by object restriction, Commission leaves you alone. Okay? If it's not an appreciable, you show, or the Commission has to prove, that in spite of your low market shares, it has an effect upon trade between member states, an appreciable effect upon trade between member states. Okay? So it's not automatic, but it's a defense. You see that? Okay. Whoops, I don't want that. Okay. Relationship between 101 and 103. This is very interesting, and it's very interesting for a number of reasons. Okay. The first reason that is important is, of course, because of 101.3 provides a defense to, although theoretical, to anti-competitive activities. The second reason is that historically it shows a very interesting and some would argue concerning developments in the way the Commission looks at agreements and looks at anti-competitive practices. And third, related to that, actually, is the fact that the Commission's looking at the practices in this new way may be contrary to what the treaty says. So the Commission may be doing something that's actually wrong. And this has significant impact for things such as environmental policy, perhaps potentially employment policy and the like in the EU. Okay, now, what we'll look at first of all is the elements of 101.3 and then 101.3's criteria, and then I'll talk more generally about how things fit in. 101.3, provisions of paragraph 1, that's 101.1, may be declared inapplicable to various where the agreement contributes to improving the production or distribution of goods, promoting technical, which does not impose on the undertakings concerned indispensable restrictions, and cut down on competition. Okay, so let's look at the criteria. For a practice that would otherwise be a violation of Article 101.1, that practice, can be defended or can be legalized if you can show that it contributes to improving the production or distribution of goods or promoting technical or economic progress. In other words, there's some sort of pro-competitive efficiencies in the production process, tending to make it cheaper or better, the distribution process, technical or efficiency process, and which does not, while allowing consumers a fair share of the resulting benefit. So even though there's an anti-competitive element, consumers still get something out of it, okay, and which does not impose on the undertakings restrictions that are not indispensable. So every restriction must somehow advance this technical or economic progress, okay, and it doesn't eliminate competition.
Wouldn't you, with that criteria, though, wouldn't you also be able to say that that's what MasterCard was doing, where in the lack of discussion they created this agreement, which was to the
Yeah.
benefit of consumers and
That's
competition?
exactly right. MasterCard's, it was thrown back because the commission didn't really understand the nature, didn't analyze the nature on the two-sided market, and all of these advantages were probably present. So what happened with MasterCard is commission produced a decision, said the MIF violated EU law. That was appealed to the Court of First Instance. Court of First Instance, yeah, I guess so, the commission's right. And then the Court of Justice said, no, you really messed up when you looked at the market analysis. Yeah, you know, this is completely off base. We're going to annul the decision and send it back to the commission, okay, to rethink. And it's probably in these cases, you wouldn't have to use this defense. What you're trying to do is you're trying to say that it would be a by object restriction. Sorry, it's not a by. Sorry, MasterCard would have to say yes, it is restrictive, but it's an effects-based restriction,
No object.
not an object, as the commission first thought. And even though it's an effect-based restriction, the market conditions are more competitive in the presence of this multilateral interchange fee than in the absence, because it would narrow consumer choices, it would so on and so forth. Okay. Okay, so those are the criteria. Okay, so first criterion, improving the production and distribution of goods, production of or technical or economic progress. So some efficiency gains, allows the consumers a fair share, does not impose indispensable restrictions, and does not afford the elimination of competition. Now these criteria are cumulative. Okay? If you're going to attempt to justify a practice, all must be satisfied. Okay? And again, you see that line, it's repeated. Okay? In principle, any agreement can be saved by 1013. In principle. Now, the change. Prior to May 1st, 2004, when Regulation 1/2003 took place, came into place. Okay. Regulation 17 applied. Remember I spoke briefly about Regulation 17 way back when. Regulation 17 said that any undertakings, okay, who wished to make between or among themselves an agreement or a practice that would restrict competition would have to notify the commission. Okay. And the commission would determine A, if it violated 1011, and B, if it could be saved under 1013. Those were the old days, the good or bad old days. The bad part of the old days was, as I mentioned, it took forever for the commission to make a decision as to whether or not the practice violated 101 or if not it could be saved under 1013. Many years in a lot of cases. Okay? The problem with that is that the companies involved couldn't put into place their arrangements. The market may have changed in a couple of years, so on and so forth. Real problem. So that was the bad part of the old days. The good part of the old days is, as we will see, the commission approved a lot of cases on the basis of 1013. It was really only after May 1st, 2004-ish that the new regime came into place and the commission got stingy. Well, the approach to 1013 got stingy. Well, that should be does. It's not patented typo. Okay. Now, a couple of now the new regime.
So many cases for 1013 were approved under the old regime.
Yep. And in fact, cases that looked all, and I'll show this probably tomorrow, cases that were almost identical in their fact pattern, that were approved under the old regime, were prohibited under the new regime. Okay. Bit shocking, but now, the new regime, Regulation 1/2003, now requires undertakings to self-assess. Okay, the Commission is not in the business of looking at your proposed agreements. You need to determine for yourselves whether the agreement violates 1011, and if so, can it be saved by 1013? Okay. Commission doesn't do that job anymore. Okay? Now, in doing this, the Commission has put into place some rather strict guidelines. You should look at where is it? It's the Commission guidance on, let me see, right, Commission notice guidelines on the application of Article 81.3, now 101.3 of the treaty, okay, and that coincidentally came in force on the 27th of April 2004. In other words, a few days before the new regime came into place. Okay? Putting people on notice that new regulation, new regime, new way of assessing things. Okay? Now if you look at that guidance, it's in the book, you can download it as well, you will see the Commission has an exclusive focus on consumer welfare. Okay? Almost nothing else counts. In fact, not almost nothing else counts. Okay. There are a number of reasons for this. Okay. In the old days, where the Commission made the decision, the Commission could balance one thing off against another. As we will see, the Commission at one time was able to balance off environmental effects or employment effects against price rises. Okay? In the new days, okay, starting May 1st, 2004, no such balancing was allowed because it became a self-assessment regime. If people were allowed to balance things off and come up with their own determination, you're going to get situations where environmental or employment concerns are really nothing more than disguises for price-fixing cartels. Okay? And people using the talk of environment or employment or whatever as a disguise for jacking up the price and pocketing the profits. Okay, and the commission realized that. So you have one metric alone, consumer welfare. Secondly, while the commission was able to do that, was able to keep in mind what it had done in the past, it sort of had that institutional memory. Okay, that memory wouldn't be present under the new regime of self-assessment. Self-assessment could no longer really occur after May 1st, 2004, not just because of the regulation. The starting date of the regulation was put into place for another reason. What happened in the EU on May 1st, 2004? It went out and had 15 members, and then the 10 4, and then it went up by 10, from 15 to 25 member states. So think of all the extra work that would be involved. Okay? Now, burden of proof.
Question.
Yeah.
In light of the exam, when doing the problem question, when it comes to sort of like 101 restrictions, would it be like somewhere at the end it'd be like they could use 1013, but it's up to the commission or the court, however it is almost impossible to satisfy in light of recent case law? Or would we be going through like all this criteria, the elements?
I would expect a complete answer would mention that the 4 elements and show how it couldn't be addressed. And then the conclusion would be the conclusion you just stated. But I need to show the workings. Now in the review session, so yes, you have to know these, okay? But in the review session, what I tend to do what I do in the review session is I go through, in effect, talk you through what would be a flow chart, how you would answer the 101 and the 102 question. Okay, and one of the things would be a 103, 101.3 defense, the 4 criteria, a sentence or 2 showing, what the problem is, and then that conclusion. Okay? It's all fairly mechanical, solving a 101 and a 102 question. Okay? There's various steps you have to go through. It's an open book exam, so you can bring in a flow chart or a checklist and work from it. Okay? And it's a very good way of studying, preparing for the exams, putting together a flow chart. Okay? There's nothing wrong with using flow charts and checklists. As I said, pilots do it all the time, surgeons do it, lawyers do it. When I was in practice, we would get essentially a checklist of very common things that we had to do and follow it. And believe me, if there was a problem and you hadn't gone through that checklist and something was unchecked, your insurer wouldn't be happy with that. Okay, so use them. Okay, in any event, burden of proof. Okay, it's up to the commission or the National Competition Authority or the plaintiff in a private action to prove breach of 101.1. 81 and 101 are the same treaty, just renumbered, or a breach of 82. Okay, and the undertaking involved, the burden of proof falls upon the undertaking involved to establish a defense under 101.3. Okay, that's key. So it puts so it's up to the undertaking involved to muster up and present this evidence. Okay, efficiency gains is the first of the criteria. Okay. that the improvement cannot be identified with the parties obtained from the improvement must be displayed in appreciably objective advantages of such a character to compensate for the disadvantages. Okay? So, it's not improvement for the parties to the agreement, but also to the customers. This is MasterCard. Two-sided market, interchange fees. Okay. So the examination of the agreement, goods and services, must be undertaken by factual arguments and evidence provided by the undertakings. This is also recognized by the Commission in the guidelines. If an undertaking is trying to establish the burden or trying to meet the burden imposed upon them by justifying their practice under 101.3, they must present factual arguments and concrete evidence. No hand waving. This is good for the consumer because a lot of people will use the cards. No. How many? How often? How would that affect the other side of the market? How many merchants would decline to use the cards? Okay. Concrete evidence, factual arguments, no hand waving. Okay. And the Commission guidelines, as I said, all efficiency claims must be substantiated by the nature of the claim deficiencies, the link between the agreements. How does this particular agreement cause these efficiencies to materialize in the market? Okay. The likelihood and magnitude. How big are these savings, the efficiencies? Are they certain? Okay. How and when will each efficiency be achieved? Sometime in the future doesn't work. This will take about 3 to 5 years to show. This might take another 10 years. Sometime in the future is vague hand waving. Okay. So look at the Commission guidelines. Commission guidelines are very important here. Read that document. Okay. The two guidelines that you should be familiar with are guidelines on the product market and these Commission guidelines. So far, there'll be a few more guidelines. Yes.
Yes, but how? But what's the relevance of how?
What's the relevance of how?
Yes.
How does this? In what way will the agreement produce the efficiencies, the claimed efficiencies? How will an imposed multilateral interchange fee make for a wider use of the card? How does that? Okay, so that's the relevance of how. Okay. So, okay. And in the MasterCard, the nature and specific features of the sector, okay, and to show the nature of all, how it affects all consumers in the relevant markets. Okay. Various types of efficiencies. You can look at the guidelines. I suggest, okay, so we have guidelines and market definition, guidelines on 101.3, a few other guidelines. So those two guidelines, read, know, bring to exam, hint. Okay. Cost efficiencies are some efficiencies, synergies in production. If two companies agree to cooperate, for instance, they may be able to produce all of their products cheaper through economies of scale, through agreeing upon various processes. There's also qualitative efficiencies. Companies can get together to improve the quality of their product by using each other's intellectual property, for instance. So there's some types of efficiencies that might be present. What about non-competition efficiencies? A cleaner environment, more people employed, for instance. Guidelines 33 seems to rule this out. Aim of the competition rules is for that competition in the market as a means of enhancing consumer welfare. Okay? Exclusive on these guidelines. You can read them as being focused exclusively and strictly on consumer welfare. Anything but consumer welfare is irrelevant
In terms of the market,
in terms of the gains. Yes.
because then could you technically say improved employment and environment is benefit to the consumers?
You'd have to do that a long way, but show how and the, what are the two, what's in the syllabus? I think it's the second tutorial, I think it is. Yes, it's the second tutorial. We'll talk about that. Okay, where this involved this fact pattern involves animal welfare, and for animal welfare you could read environment. You could do that. You just have to change the facts. But it's obviously if you read the syllabus carefully, you'll see that this fact pattern is based upon a real consideration that came out of actually the Netherlands. Yes.
Yes. How about it have a fast in both ways? That on one side it enhances consumer welfare, but on the other side it could be anti-competitive.
Okay. Yeah. Then you have to look. Does it? Okay. All of the restrictions that you're dealing with, okay, will be anti-competitive. Okay, because if it's not anti-competitive, it doesn't fall into 1011, right? Now, if it's anti-competitive, but consumers get something out of it, it would depend upon what they get out of it, how much they lose, and what other options are available. That goes in.
Is it essentially do the advantages outweigh the disadvantages?
Yeah, essentially, but it's advantages only to a very narrow to the consumers.
So like if there a lot of advantages but disadvantages to consumer, then just
Forget it.
as long
Or
as
disadvantages to the consumer who paid for the product,
as long as advantages are to the consumer,
who pays for the product.
yeah. Okay.
Okay? So, and we'll get to that. Now, the non-competition efficiencies. Now look, as I said, this is past practice. All of this was before 2004. Okay? These were, okay, commission decisions that under 101, or actually 85.3 and 81.3, the former 101.3, that had restrictive practices, okay, that granted, that had benefits that couldn't be measured or weren't measured exclusively in consumer welfare, and yet were approved. Okay? Ford and Volkswagen approved a joint venture to create 10,000 jobs in Spain and Portugal. And they just joined the common market. Synthetic fibers. In 1984, nylon and Dacron, those polyester fibers that people used to wear clothes. I guess it's because the disco people was over. Nobody were. So orderly industry restructuring, which is a nice way of saying production cartels. Same in the Dutch brick industry 10 years ago. Environmental pollution, and this involved phasing out certain white goods, washing machines. I'll talk about these in more detail, but past practice included and permitted taking in non-consumer welfare considerations into account in a 101.3 evaluation. So with that, we'll stop. And I guess we'll start again with non-competition deficiencies next time. Now look, as I said, a couple of guidelines. Market definition guideline is key. Guidelines on 1013, also important, okay? Two important commission documents. Please have a look at them. Please keep up with the readings, okay? So we'll see you tomorrow. Figure out how to shut this down.
I think you can just click this one.
Okay, which one is it? Control.
No, control these two and then
Oh, control. Okay, control. Delete. Okay, the old one. The up and down.
I just wanted to ask, you know, the syllabus, you didn't really state like how many questions will be in the exam and how many we will need to answer.
I know. Because I wrote the syllabus first, and then I wrote the exam. The exam is 3 hours. You have to write 3 questions. The exam itself has 2 sections, Section A and Section B. Section A will be a number of essay-type questions dealing with themes that come up with recurring themes. Question B will be problem questions, 5 problems. You'll have to answer one from A, one from B, and another one of your choice. I don't know how much. I wrote the exam in September.
Oh.
Okay. So I'll have to check. Okay. But I think there's at least 3 questions in each. It might be 4 or 1. Okay. So there's just, I get choice. Okay.
Are you confused about the example that Sina made?
The what?
The example that Sina made about disadvantage and advantage.
Yeah.
That means if I can prove that if I was undertaking that I would prove that my agreement is not competitive.
Right.
All I need to approve that my family or I have.
First thing.
Okay.
There's 3 other things you have to look at. So that basically there are benefits that the consumer gets that couldn't be obtained in anywhere else. This is the least restrictive manner possible, which is always difficult because you can always find something less restrictive. And then it doesn't constrain competition too much. So there's 4 things. This is just the first step.
Okay. So the first step that I need to put all the benefits or exclusive for the consumer.
Yeah, you need to show that the consumer gets these benefits. No, well, no, it's not that all the benefits, but of those benefits, the consumer gets a fair amount of benefits. There could be other benefits, but we don't look at those. We look at what the consumer gets. Okay?